Well, the attendees will start slowly trickling in. Meanwhile, let's just start. Hello, everyone. I'm Shikhar, the convener of the Law and Tech Society 2022-2023. Thank you all for joining us here at admittedly short notice. Uh, I will not waste any of your time because I realize we have a lot of things planned for today's discussion. I'll just directly jump in and introduce the moderator for today's discussion. Miss Malavika Raghavan here is currently a doctoral candidate at the London School of Economics. She is undertaking cross-disciplinary research in a host of disciplines on law and information systems. She is also a senior fellow at the Future for Privacy Forum and a visiting faculty at Daksha Fellowship at Sai University. Through all of these, and also at her previous role as the head of the Future of Finance Initiative at Jauhar Research, she has engaged deeply with many iterations of the various data protection bills we have had, and I'm sure should be a stellar moderator. Over to you, Malvik.
Thank you so much, Shikhar, and thanks to everyone for joining on a Saturday again at short notice, not least the panelists. I think one of the things I was saying on the pre-call or pre-correspondence with this is I definitely do not want to be the moderate moderator because we have an excellent panel. I'm not going to, in the interest of time, I'm not going to read out each of their bios, but I'm going to request each of you before you begin your opening comments just to share whatever you would like the audience to say in terms of your relationship with the DPDP bill. Just a couple of things up front on timing and how we're going to spend the next 90 minutes. I think essentially we're going to do a first round of kind of opening comments from all of the panelists, and then we'll go into our main discussion. This is an interesting panel that we have before us as well, because we have people in the private sector who are doing non-profit research as well as in practice. So I think it's very interesting because we have both people who are advising clients and people who are going to court. So all of us are engaged in this bill. So you see that entire trajectory from policymaking into the law. And I think the most interesting part, even after the last, depending on how you count it, 10 years to 6 years of consultation, is going to be a super interesting journey. Again, the last bit of context to share is that even though we talk about this bill as having consulted since 2015 or 16, depending on how you count it, I really think August last year was a watershed moment in terms of the withdrawal of the previous bill. And what we saw in December, the last time we all spoke as a group, was something that is quite brand new. And I think what's interesting is that what we've then had passed in Parliament really departs in many ways from how things evolved through the consultation, starting with the Sri Krishna committee. So with that, I'm going to go to the panelists with the first kind of their opening comments. And the provocation here from me is, what is one aspect of the DPDP bill that most raised your eyebrows, that you pondered most in the last month, and why? So just a couple of minutes, if you could introduce yourselves. I'll start with Sriya, and then if you could hand over to Arun, then Ameen, and then Vivek, if that works well. And thank you so much for being with us. Over to you, Sriya.
Thanks a lot, Malavika, and thank you to all my co-panelists, the Law Tech Society, and all the attendees for this enthusiastic weekend session. There's a lot to talk about and a lot to unpack. A brief introduction about myself before I get started. I am currently in-house counsel at Setu, which is a fintech API infrastructure company, part of the Pine Labs group. And as a part of my work in this role and my previous role, I've been deeply steeped in practice of law and as it relates to emerging technologies. And so I've been following this bill basically ever since the first draft came about, and it has been sort of a passion project for me to keep tracing how it has evolved. Now, that being said, I guess what has been on my mind the most since we had our final act, I keep saying bill instinctively and I keep forgetting to say act, but what has been most present on my mind is just the stark difference between where we started and where we ended up. And I think perhaps taking that bird's eye view is what I've been fixated on, because where we started was a very, very comprehensive draft. I would say I'm interested to hear any differing opinions, but I think it was a very, very comprehensive draft, almost sort of trying to emulate the GDPR in many ways, trying to draw from that. And most of the provisions mirrored the GDPR in some way or the other. While, of course, it was still heavily a consent-based legislation, it did try to counteract the pitfalls of a consent-based approach to privacy by including wide definitions of harm, by including provisions for privacy by design, for example. However, what we've ended up with now is a largely diluted version of that initial draft, and taking apart all of those provisions which counteracted against the pitfalls of a consent-based legislation. Now it is essentially purely consent-based, and I would actually argue, especially as somebody who is responsible for company compliance, it is a slightly extended version of the erstwhile SPDI rules. We will have to, of course, wait and see the number of rules that come out pursuant to this, because a lot has been left to subordinate legislation. But as it stands right now, it isn't too much of a jump, other than say maybe 5 or 6 things, too much of a jump than what we had before. So I suppose that's what's been on my mind, and I'm not too sure the rationale for why it has come down in sort of its stringency, its comprehensiveness. I'm not sure why. But I guess whether that's a good or bad thing is depends on who you are, right? If I wear my business hat, I'm fairly happy actually from a company compliance perspective, and I'm sure that many would agree. As a citizen, not so happy, because I am seeing the different effects it may have on my individual privacy. Some of them pretty adverse. So that's where I would close my opening comments and pass it on to Arun. I'm excited to see what everyone else has to say.
Hey, thanks, Sriya. Hi, my name is Arun Prabhu. I'm a partner with CAM, and I've been looking at various versions, practicing law since 2005, sort of looking at various versions of the bill since then. I actually have a slightly different perspective on this. I feel the version of the bill that was before Parliament for enactment circa 2021 was a bit of a monster. It was GDPR++. There were parts which simply did not belong, and I've taken public positions on this. Parts that didn't belong, which had been grafted onto it, like non-personal data, so on and so forth. I mean, it was while the 2018 version was well thought out and well reasoned, I think it was scribbled on with crayons by various people since then. And then, of course, the Joint Parliamentary Committee, in whatever they did, I think grafted on parts to it, which to my mind would have been extremely problematic had this been enacted. I also feel that, and I'm not singing to the choir here, but I do feel that as a society, we must be mindful of the current state of our data protection enforcement and our data protection culture. Europe, when the GDPR came into force, had been subject to the data protection directive for many years. They had things like Costa versus Spain, they had decisions of the courts and so on and so forth. And there was and to be frank, since the Holocaust, I think Europe has been very, very mindful about what can be done with data. And as a culture, they've always been protective of privacy culturally. Now, I'm not going to say, like lots of folks have done, that we don't have privacy in India, or we don't have privacy in Asia. But I will say that the base level of protection today under the SPDI rules, there is more observance and breach than there is in compliance, fundamentally, right? I mean, lawyers may like to talk about it, but we know you can buy full records end to end for several paise on the internet today. And that's just where the market is. To me, the old version would have been a massive step up. Moving to the current version, and what's occupied my head between when I saw it in August is two things. One, the sheer speed of it, right? If we look at the revised version, it came out in November. Between November and August, they've pushed it through both houses of parliament, they've enacted it. The sheer speed of it, frankly, took me a little bit by surprise. What also concerned me in a couple of ways, and this is again, Sriya, where I'm slightly differing with you, is this architecture which has been created on the regulatory side, right? The Data Protection Board, which by the way has no rule-making power, it's effectively only an enforcement body, and then appeal to TDSAT, right, which takes it completely out of the ambit of the high courts, the constitutional courts. Appeal to Supreme Court only on limited matters. So you're creating a very lean regulatory mechanism which only has grievances and penalties in place, and we've seen under the intermediary rules what that's done, right? So given that framework, I actually look at this with a little bit of concern. While these rules may not look very different from the SPDI rules today, I think the fact that they expand to all personal data and the fact that you have this heavily purpose-based regime, which is even artificially constrained by having a deemed obsolescence threshold, and having a deemed necessity threshold hard-coded into the law actually creates, to my mind, a very onerous regime in practicality. And we will only find out whether you're compliant or not after the breach occurs, because that is when you will sort of go before this data protection board, which will be, essentially the composition of that board concerns me a little. So that's my takeaway from here. I come away a little bit relieved that we have a lean law, but concerned about how it's going to be enforced. I'll hand over to Ameen, if that's okay, Malavika.
Thanks, Arun, and thanks, Sriya. I'm actually, so I think, yeah, my name's Ameen Jauhar. I'm currently working with the Reddy Center for Legal Policy, which is an independent think tank that works on a wide range of issues. I lead Reddy's work on law and technology. And of course, given that I work on law and tech, data protection is, of course, one of the key focus areas for me. So I think for me, there were like 2 points that I wanted to flag. Arun actually covered a bit of it in terms of where he said that, we need to evaluate this data protection law in the context of where we are in India in terms of digital rights as a whole, especially your individual right to privacy. We often tend to take the yardstick of EU or certain parts of the EU or the North Atlantic perspectives, which I think is a bit flawed in that perception. Like, I think our own evolution course is different. But even before that, I think, to me, as has been covered by Shreya, as has been covered in some points even by Arun, I think the difference between the different iterations is it shows a work in progress kind of approach, which I feel, to be honest, like, I would say that there are certain continuums in the bill, in the act now, and there are certain radical departures from what we were or where we were in 2018-19 to where we are today. And just to flag a couple of examples, I think the continuum is, for me, the sweeping exemptions to the state. This is clearly a legislation that is primarily to regulate the private sector's data processes. That is very, very evident even from the first iteration that ever came out, except for Puttaswamy. As of today, we don't really have a real safeguard or a real check and balance in terms of how do state data processes work and how will they be regulated. And this seems to have continued as a pattern throughout the different iterations. The difference to me is, like, the most stark one was probably the position around cross-border data transfers, which I think, like, when you look at the 2017-18 bills, was coming in the context, I felt like, yes, we were taking inspiration. No, actually, there we were even departing a bit from the GDPR, because we were intensively proposing the idea of data localization, which is something I know, like, Vidhi was a strong proponent of, but I'm taking my personal view here. But I think that came in the context of, we had a flurry of these scandals, starting with Cambridge Analytica and a lot of these instances, which I felt sort of contextualized a lot of this, like, big tech processing data in an unbridled manner is probably something that was problematic. And even in terms of when you're talking about cross-border data transfers, I think that was a strong consideration to where we are currently, where India is now very actively seeking to develop its own data economy. We are looking to be much more flexible with how non-personal data sets are made available. Government is actively trying to promote it, especially under the National Program of AI. METI has come out with this draft data governance management framework last year, which to me sort of fits the idea that we are at this point where, if we had a very stringent data localization regime in place, this ambition that Indian uh, politics at this point seems to depict is not going to be satisfied. So for me, I think the shifts in some of these key provisions between the 2017 and 18 versions to where we are currently in the act sort of stem from that recalibration and recognition or evolution in your legislative and policy ideas around where we see India's trajectory in this digital economy, in a space where we want to be front runners in AI innovation. We want to tap into that market. So I think, like, that all, certainly to me from a policy standpoint, seems to have influenced even this radical shift in the draft of the data protection law. So yeah, with that, I think I'll just pass over to Vivek.
Hi, this is Vivek. I've been litigating and advising on data privacy and technology issues for the last 2 decades. I'm a senior counsel in the High Court and the Supreme Court. So I echo what Arun is saying, and I understand that the 2018 draft was the robust data protection law. But as I said in my previous, at least the last session, that was a great bill on paper, but would have only created an entire culture of non-compliance. The entire industry would be non-compliant on day one. Arun makes this point well, that fundamentally data protection law has to be an iterative and incremental process. You can't have a robust law on day one. Even GDPR, that after GDPR came in, several entities till the last day, they got a 2-year transition window. And even on the last day, companies were still hampering on non-compliance. There is a culture of non-compliance in GDPR, even as we speak, despite 2 decades of data protection directive. So there is no point in having a great law on paper. It's like the Indian Penal Code, having a great law on paper and having a culture of non-compliance at this one. So I think it's very critical that we start incrementally and then add on blocks, as opposed to building a full-fledged block and be non-compliant on day one. It simply does not increase the privacy approach. The 3 issues which worry me the most under this bill. Number 1, we have followed a GDPR plus standard for consent. Consent, the way it has been done, consent is hard. It's very difficult for several players to follow that consent standard currently we have under the bill. And if the GDPR interpretation of consent flows into India, again, several of us, as I said, the industry players will again be non-compliant. We have seen the problem in Turkey when you get a new data protection law and we don't have a culture of non-compliance, the entire industry is being held to be non-compliant. That simply will not fly. You will find most people to be non-compliant. That's the reason why in GDPR, they give the 2 alternate legal bases, contractual necessity and legitimate interests, to avoid the rigors of consent. This is a developed market. We do not have that. So if we are going to have the same rigorous standard minus the alternative legal basis, I can very safely say that there will be again a huge culture of non-compliance. Second issue, which I'm extremely worried about, is that an entire generation of India is coming online. Minus it requires verifiable parental consent. There's an entire generation whose parents are illiterate. How are you going to take their consent? Are you going to block off the internet if you can't get parental consent? That's purely from a citizen perspective. And third, I think we are very close to our country is a very extensive social media market. If the EU consent model is adopted, we'll very, very soon see a bifurcated social media experience. There will be a paid social media and there will be a free social media. And that's how this one is done. I also want to comment on data breach, a very loose standard of data breach. And I disagree with Ameen on why data patriotism is good for India. I don't think so. We are the early beneficiaries of data globalization. People who are from the South, Hyderabad, Bangalore, Pune, we benefited from data coming into the country. And I think data globalization is very good. The bill takes a right stand on ensuring that we have avoiding data patriotism. Over to you.
Thanks to everyone. That was a really excellent round of opening comments. I think we've already kind of picked up on, I think at least I can see about 6 or 7 key issues in the bill. And I think what makes these kinds of discussions both so dynamic, but also hard to constrain in the next, however many minutes, kind of 60 minutes that we have, is that we're both talking at the high level, right? What is data? Is it an asset? What is the role of the data protection bill? Is it trying to protect privacy? Is it trying to do cross-border flows for data, for trade? And those kinds of, do we have a culture of privacy? But we also have these very specific implementational issues, right? How are we going to deal with the absence of any transitional provisions in this law, which previous iterations did have, or at least give you a roadmap of how there's going to be a staging? And maybe we can pick up there, because I thought the first thing, because all of you talked about this, the fact that we've moved from an initial proposal, I'm thinking of the white paper in 2017, which was a co-regulatory model, super light, kind of industry codes led. We moved to this 2018 bill where we said we'll have an independent regulator, we'll have grounds of processing. And now we really find ourselves, as many of you mentioned, in this consent world, right? So consent was apparently dead, but we've come back and put our entire data protection law at its feet. So my question really is, how do you see consent and legitimate use interacting? I think that's a very interesting, especially for people who are on this call, who are law students and might be applying this law. I think that legitimate use grounds, I'm thinking of 7 and 7A here. How to make sense of that? So if you're an organization, consent seems inappropriate or unachievable. What is the role of this legitimate use? And I don't know if I should share my screen, but I'll just read out that provision before I pass it back to the panelists. And I think maybe I'll start with you, Vivek, and then Ameen, Sriya, Arun, whoever wants to jump in. But if I read this provision, it is, I was taught a statutory interpretation and drafting by Vepa Sarathi, and he was probably doing a 360 in his grave, because this provision reads, the certain legitimate uses, and it says that the data fiduciary may process the personal data of a data principal for a purpose which has not been specified, where she has not indicated to the data fiduciary that she does not consent to the use of her personal data. She has not indicated that she does not consent. So please solve that puzzle to me. I'm coming back to you, Vivek, and then I'll invite all of the...
interlude. It says she, so everything is fine. Sorry, back to Vivek.
No, sorry, it says she.
It says she, so everything is fine. You know, everyone's happy. Sorry, back to Vivek.
Yeah. Exactly. Back to Vivek. Yeah.
Malavika, that's if there's one provision where by heart to memory in this entire bill, it is that provision, because the entire industry is trying to figure out how much data we can pack through that window or through that door. In my view, I think the way the bill does not indicate any hierarchy of legal basis. It doesn't say this is one, this is preferred, this is the other. But the way it has been, how narrow it has been drafted, I think consent is the main gate and this is the side gate. A lot of people are differing with me. They're saying that why can't this be the main door itself? In my mind, to satisfy that standard, two requirements have to be satisfied. Number one, I must clearly communicate a purpose, and two, there must be direct correlation with that purpose. So if I put up 15 different purposes, if a hospital, if an insurance company puts up 15 different purposes in their privacy policy, and they say the user has voluntarily provided data, I think it will not satisfy that standard. It has to be a specific purpose and a specific processing to a direct correlation with that purpose. I believe that's the best use case of it. People want to stretch the law and pack in multiple purposes. I fear that the more purposes you add, it becomes indefensible and you have to hark back to consent. I hope I answered your question.
The last version had some very helpful language, right? Where it is reasonably apparent. Now, if you look at the genesis of this is actually taken from Singapore's DPDP, right? And basically, they're looking at a situation. I mean, I'm glad they got rid of legal consent, but they're looking at a situation where, from the circumstances of an underlying transaction, it is fairly evident that the data was given for that purpose, right? So I echo Vivek here. I don't think you can be trite about this and sort of, put in vaguely related things in some form of notice. But I do feel that this will largely cover stuff where an independent observer, an impartial observer may look at it and say, hey, this was but obvious, right? So circumstances like that, to my mind, will be covered through it, but I feel it is nowhere near broad enough to cover the consent corridor or the consent barrier as we speak. I also feel, and this is, the other way they've tried to solve for this, at least for themselves, is to put in all of these overlapping exceptions for legal purpose, legitimate purpose, comparison of, not legitimate purpose, that's a bad word. Complying with legal obligation, complying with government obligation, instrumentality of state, basically a whole bunch of belt and suspenders type language there effectively. But I think what they've forgotten is that the constitutional courts of this country have not gone anywhere. To my mind, the act is a interpretation or legislative interpretation of the broader constitutional principle of privacy as outlined in Kutaswamy, vaguely as it was done. And I suspect that if government processing exceeds one of those thresholds, right? Let's take, for instance, Aadhaar. If you could strike down a 3-year retention period on the basis that something should only be retained for 6 months. And that philosophy continues in future courts, God hope, I hope they do. Then actions which are deemed to be permissible under black letter law under the statute will still be read carefully by courts to see if they meet the constitutional standard of minimization. So I think it's an interesting, I mean, they've tried to solve for it in other ways, but not very well.
Can I add to that point that Arun just made? So I also think this, like my reading of this was that one, compared to, I don't know, like how the others feel on this panel, but like compared to the language of the deemed consent provision that was there in the 2022 bill, this is certainly leaps and bounds better drafted. And like I have several reasons for that, starting from the idea that the opening premise of that provision was that consent has been deemed to be given. Now this is like in a law that is heavily reliant on consent based data processing, and I was struggling to find similar kind of deemed consent as a notion where you are basically like what it was de facto doing is that we are going for non-consensual data processing, but calling it as a consent based thing. Here the language itself is that this is going to be read as an exceptional legitimate use to the idea of consent, is how I am reading it, which is where I feel like when Puttaswamy also talks about legitimate purpose, it says that that is one of the prongs to exceptionally violate or transgress an individual's privacy by the state. And what Arun was saying, like I think this narrowing down of what deemed consent was trying to do has been there across the different clauses or different parts of this section 7. So like I think like when you read different clauses, for instance, on this purpose of where we are following a function under the law, I think they've now sort of bifurcated that in subclauses C and D. And in that, I think one of those two provisions also says that it has to be done in accordance with what is the current legal provision with respect to data privacy, etc. So what Arun was saying, that whatever action you are taking is not unbridled, and constitutional courts will have that oversight here, even if you're talking about data processing that a private data fiduciary may be doing for a function under the law, will have to be compliant with the thresholds in Puttaswamy and will have to be done in accordance with what the constitutional courts have upheld there. I also felt that there was this one subclause D, which was very interesting to me, at least, which is around this obligation. I felt that this was probably one of those areas where they might be able to go around this end-to-end encryption issue in WhatsApp and Telegram, because it feels like whenever they have tried to do that previously, a lot of these companies have backlashed on the fact that we have informational privacy to safeguard, etc. And now they have created this as a like a very sweeping sort of exemption to informational privacy, where they say that if under a law you are required, which they are required to do so, I would say under the intermediary guidelines, then the government may actually say that we are also protecting you from any potential claims against you in a privacy suit or something, and you have to do this. So that subclause D, for instance, was very interesting. But overall, I felt that this legitimate use one, I think, is more defensible for the government in the way it has been drafted, because I think it brings out a narrowness to the scope in certain cases. And two, I'm just a bit more happy that they're not doing with this on the face of it. They're not using language like consent has been deemed to be given. That concept as a whole, it seems a bit flawed in its creation, and I'm just looking forward to them creating this as a second layer of exceptions that they're giving to private data fiduciaries rather than just the state data fiduciaries.
Sriya, you want to come in?
Yeah, so I actually agree with Ameen when he talked about how it is better than the deemed consent provision that was there earlier, because I actually think the way that it was drafted previously had the potential to actually be greatly dangerous, in a sense of like giving a very, very blanket wide space for businesses to collect data, hither and thither without any sort of accountability. And I think that ultimately this is a legislation, and I see this being mindful of the business space as well. It is a legislation that has to create accountability, and we need it. That being said, a very similar comment I have, I think the other panelists have covered a lot of what I wanted to say, but a very similar comment I had from the deemed consent space is how this is actually even irrelevant to some sectors. So being from fintech and financial services, this is after discussion with several people in the same sector. This is a section that really the financial sector isn't going to be using. even if it gives you a way to not provide a specific notice, even if it gives you a way to kind of get around consent requirements, which are otherwise difficult to implement, the financial sector is going to implement it. Because very interestingly, and this is something I highlighted last time also, in the long road that it has taken us to get here, the financial sector regulators just went ahead and created a data protection cybersecurity regime of their own. They said, we're not going to be waiting for this, because in this gap, we are unclear with the amount of innovation in fintech, the amount of data being processed, data sharing between regulated and unregulated entities. We're not going to be waiting for a data protection law standalone. We're going to be creating a whole regime. And with the regime that is there, at least from RBI, SEBI, IRDAI, now with new data empowerment frameworks like account aggregator, I am first-hand privy to exactly how stringent that is, and the measures that need to be taken to ensure informed consent. And so I think legitimate use like this is, I'm curious who it's more for, because it's definitely not for sectors which are highly regulated. In any case, they're not going to be using this at all.
I can just close out the loop.
Yeah,
I'll take 10 seconds. No, Ameen and Sriya, I see a common thread in both of you. Like, hey, this is very well drafted. It's very narrow. I agree with you. It's very narrow and very well drafted. But when you create a narrow alternate legal basis, then you are pushing the bulk of the industry, the non-fintech, from a small law firm to any player into the consent bucket. If the consent threshold is difficult to satisfy, the industry will push, and I can say with confidence, successfully, to reduce the threshold of the consent, which will be a less privacy protective experience everywhere. So putting all eggs in the consent basket it's not necessarily more protective of the rights of the citizen. That's why EU recognizes that. They give you other legal bases which are also doing that. Now you draft a narrow exception, you say consent is the only gate. It defeats the objective of creating a more robust data protection. Thanks, Malavika.
Yeah, and that was super interesting discussion. So just to give context to some of the people tuning in who may not have as closely followed many of the iterations of the bill, I think essentially what we are reacting here is the previous iteration, or the brand new bill which came in December, where there was this provision of deemed consent, where they could assume that where you had not consented, certain categories of data could just be stated that you have deemed to have consent, kind of like our, in India, we love creating these legal fictions of deemed university and so on and so forth. But I do want to take us back to another interesting concept that didn't come up in these comments, right? Which we had in the previous drafts of the bill, fair and reasonable processing, for instance, reasonable expectations, which has a constitutional link as well. So again, for those of you, to take you back to Puttaswamy, one of the things that the privacy jurisprudence in India was developing was the idea of reasonable expectations, right? So even if we all know consent is broken, it's very hard to understand the associative rule mining, engine which is running in the back end and say, yes, I agree to this and that, When we consent with certain reasonable expectations. And it's interesting in 7A, and I think this ties to something else I wanted to pick up with all of the panelists, the idea that when you cannot consent, and many studies have shown that it's impossible to consent in a datafied world to all specified uses, to understand how your data is used, then really what happens to the idea of reasonable expectations? And really that's what this clause seems to be dealing with, in respect of which she has consented, right? She has not indicated that she does not consent, means in respect to which she may consent. I mean, I actually don't think it's very well drafted, but I think we could have used something, simpler, more elegant legal language that ties to our constitutional jurisprudence. And there are two things that Sriya picked up on here. This law defers to sectoral regulation, basically, which is gold plating, right? Again, another standard that it sets a base and then it sectorally regulates. And what we have in many sectors is when you're dealing with more sensitive types of data, you have a more strict regime because you're taking into account reasonable expectations of, say, someone with their financial services or their health, for instance. So I was curious if anybody had thoughts about highly sensitive areas like, say, health, which don't have the kinds of regulation yet. I mean, maybe under the health data policy, that, say, the financial sector does, and especially as those are kind of interviewing. And if I don't know if anyone does. If not, the other area that I really wanted to come back to is what Ameen raised in terms of the state exemption, because it seems this entire debate around what is consent, what is legitimate, what is reasonable, kind of is being short-circuited on the side of the state in terms of setting up a two-speed law. But before we go there, I wanted to check, has anyone done any work on health or any other sensitive areas? Yeah, go for it, Arun.
Thanks. So look, health has been a bit of a crapshoot. You saw the Medical Council of India put out these outland. I mean, if this group likes outlandish drafting, you should read that version. Put it out, completely broke the system. I was making a presentation to a hospital about this bill, and the doctors there wanted to talk about the MCI rules. They realized they were completely impractical, and those rules were ironically withdrawn. Version put out in 2002 was put back in. What they did have, interestingly, is at least on the telemedicine framework, they did provide for some basic rules in terms of anonymization, de-identification, the standard for retention, and so on and so forth. The second piece, which has become sort of important, is, and the government of India is responsible for some of this, because when Arogya Setu was challenged, they put out the Arogya Setu protocol, right, and said that, look, if we put things through this protocol, which is basically HIPAA++, it's de-identified, it's no longer personal information, so we're actually okay. And therefore, they created a little bit of a bright line anonymization test. And that bright line anonymization test is what most of the industry is following in terms of sector, just because HIPAA makes sense to align with, there are global tools to enable it, etc., etc. So I think from a health perspective, you see the industry sort of resolve into two pieces. Wherever it's identified, it's going to be a consent-based approach. And then, of course, where it's not identified, where it doesn't need to be identified, you'll see far broader uses on the basis that, the data has undergone this kind of Ganga scan and is therefore no longer protected. But I want to use this opportunity, Malavika, to raise two questions, right? I want to see what this group thinks about the definition of personal data, especially in view of data relating to an individual. Are we and in view of the definition of the word fiduciary? Are we what do we as a group think about a situation where you have a data set which has been collected for a very relevant purpose, which is provision of medical care in an immediate situation? It's running through a filter of alleged anonymization, but with no regulatory bright line protection. What do we think in case of a breach? Will that will it stand outside the protection of this act because it has been anonymized, or at least anonymized in air quotes? Or does the combination of relating to an individual and the fact that this is a fiduciary obligation, is it going to make our courts sort of take on a paternalistic approach and say, no, this data is still protected? I'd love to talk about that, but back to you.
Would anyone like to jump in on the question of identifiability?
No, I think on the pure textual reading of the law, at least the earlier bills had some sort of standards and anonymization and all that, but now that has been dropped, and on the pure textual reading of the law, on the date when the breach happened, was it personal data? And it's not potential for de-anonymization, but was it anonymized on that date? If it was anonymized on that date, and if you can't identify it a particular individual, then I think the industry would have a safe argument that, or at least a very defensible argument, that it is not personal data. I expect the rules will say something about anonymization, but I think purely in the text of law, I think that it will be a very good, it's outside the bill.
Yeah, and I think this also takes us a little bit into the scope questions, right? There are some interesting scoping questions where there are major departures in this bill from previous iterations. I mean, obviously, this choice to remove the definition of a sensitive, that is we don't have a category of sensitive personal data as we do, say, under our existing IT rules. We just have this broader category of personal data currently. But I think another interesting one is this idea of then, if that data has been made publicly available, then it's no longer under the protection of this bill, right? So there are many scoping kind of issues here, not least the exemption with the state, which I wanted to kind of bring us to for two reasons. One is, again, just to frame it for the audience before I pass it back to the panelists. Obviously, one of the big things in this bill is that it seems to be a direct pull through from Section 35 of the previous versions of the bill, where essentially the state can notify that certain instrumentalities of the state do not have to agree to this law. That's fine, right? So there were lots of constitutional issues there about whether a notification can be a means by which to abrogate your fundamental rights of privacy. Those remain, and there are lots of surveillance challenges. But I wanted to ask this group, how do you think that these state exemptions, or all of the many state-related exemptions, tie into this broader framework of the NPD, Non-Personal Data Regulation, Digital India Act, and so on? And this whole idea, which seems to me to be that data is an asset that the government wants to, in many ways, use. And that area. I mean, let's park surveillance for a minute. Obviously, it's a huge issue. We'll come back. But my question is, why do you think that the state has gone for such big exemptions? And how do you think that people on this call should be interpreting these provisions against wider legislative moves that might be happening? Again, I think, Ameen, you started with this. So I'll pass it back to you, but please feel free anyone else to jump in.
Sure. I mean, for me, I think the biggest probably, like, I'll try to correlate it to some of the other areas that I think I'm a bit aware of. So one is that I think under this, METI is currently running this national program of AI. Part of that initiative is going to be some form of AI regulation in the Digital India Act whenever that bill actually gets tabled. But I think they are very clear that they want enough data sets domestically manufactured, because I think one of the key concerns that has been flagged in the last few years repeatedly by a lot of industry, but also a lot of academics, is that whenever we have tried to create AI models or algorithms in India for ABCD purposes, ranging from, like, say we want to create a translation tool to, say, some kind of facial recognition technology, we do not have data sets based in India. We usually have to rely on non-Indian data sets, or we have to take, like, complete base models from other agencies or non-Indian entities, which overall then affects the functionality of the model that you're trying to deploy here, in terms of accuracy, in terms of data biases, etc. I think that, to me at least, is one big chunk that they have been trying to work on, because I have been in touch with several folks at METI who have, over the last 2-3 years, worked on this data governance framework. So originally, that data governance framework was just to be an update of this 2012 policy of upkeeping governmental data. But from there, that whole exercise transformed into creating a more organized regime for non-personal data collection and sharing, which is, I think, at this point, what the draft policy tries to do. It creates an institution for doing that as well internally, but, like, that policy is yet to be notified. But I think the big question here, like, I do agree with the fact that the state's intention seems to be very much in taking the economic perspective to data sets, especially non-personal data. I think this one of these arguments that we often tend to make, that there's this fine line of distinction, if you can call it so, between non-personal and personal data sets, and often there's, like, an overlap. I think those elements are not fully acknowledged or well received. If you see the kind of demarcations that they're drawing between when they talk about data sets in the non-personal data governance scheme, versus when they're drawing very clear lines here in the Data Protection Act, that this is personal identifiable data. And that is where I think, like, Vivek's point also comes in, that on the date of a breach, was it anonymized, was it de-anonymized? These are things that will become questions of fact more than law. I personally think that this dichotomy is one problematic, but the intention clearly seems to be from the government side to tap into this economy and to have, like, a free access in terms of promoting AI innovation, which I am pretty aware of is that is, like, one of their priority concerns, that they do want to bolster AI innovation, especially within health, education, urban cities, urban mobilization, and smart cities. And I feel that the loose, like, I don't know, like, to some extent exemptions are there, but again, like, I feel the broader exemptions to me are the ones that they've given in terms of national security and sovereignty, which again allows sweeping surveillance and monitoring and real-time monitoring, a point that perhaps we can come back to, even in light of what the EU's AI Act is now proposing in terms of certain restrictions on, say, real-time biometric identification systems, etc. And that is not the position that the Indian government seems to be taking, and I don't think that's going to change. I think that has been, like, a consistent point from 2017 to 2021. So yeah.
Yeah, come in. Vivek, did you want to say something?
No. This is not on the question of state, but on the question of AI, which he was taking. I thought the bill creates a barrier for AI growth in India, and it's a very categorical barrier. I wish there was a more regulated, and I understand that AI systems must not be biased. It's a big concern, and therefore they should have regulated it. But as opposed to simply it is a huge prohibition they put in. And I'm referring to what Malavika was referring earlier, that you can only use public information if it has been if it has been made public by the user. So in other words, whenever I get a public information, I then need to make another second level of inquiry. An AI operator will have to make a second level inquiry. Is that been made public by the individual concerned, or has it been made public by somebody else? And therefore, that second level of it's simply not feasible for most AI operators. So you are depriving an AI system of taking valuable publicly available information. The better course of action would have been you take it, but have a regulation around bias, ensure that it's widely available. The approach right now is that no publicly generated content can be used unless you go and take consent of the user. That simply is it's unworkable for an AI operator.
Actually, I have a question about that. Vivek. I was wondering, because the provision on publicly available data precisely says personal data is made or caused to be made publicly available. So I was wondering what your view was on. I thought actually the phrase caused to be made widens that significantly. That there is a much wider exemption for data that is even caused to be made publicly available. And actually, instead of adopting, other like comparative regulatory approaches where a certain carve out or exception is made for certain categories of public data within the bill, the whole category is now no longer considered personal data at all. This was my interpretation, but if I'm wrong, I would love to be corrected.
If I can respond, you're right. The cost to be made publicly available is indeed widens the set, but what comes after narrows the set. It said cost to be made publicly available by the data principal to whom such personal data relates. So if I'm an AI, if I'm deploying an AI system, and if I'm taking a public set, and if I find a publicly generated information, I have to also make a second level inquiry as to whom it has been made public, who has made it publicly available, or caused to be made publicly available. Has it been made publicly available by the data principal? Or let us say, for example, has it been made public available through another public source? That second level of inquiry, the AI operator will have to make it. If it is, if that inquiry fails, or if I don't do the inquiry, then my ability to access the data gets restricted.
So I want to make a slightly provocative statement here. Assuming that there is let's look at Facebook. Let's assume, let's not look at Facebook actually for specific reasons. Let's say there is a hypothetical public social media website, and that social media website has two kinds of profiles: public profiles and private profiles, right? There are profiles which are publicly available, there are profiles which are private. Assuming that there is something which is put out in public domain on that profile by somebody, to my mind, if the terms of that website clearly say that by putting something out here, you are consenting to it being made publicly available, I, as a scraping company or an AI company, can rely on that good faith belief, basically saying, hey, I believe that you have caused this to be publicly available, it's available on the public website, everybody knows about it, and potentially, to assuage some risk here, put out an opt-out, right? Saying, if you believe that your data has actually been put in an unauthorized manner, please click here and we take it out. Because to my mind, unlike the consent obligation where the burden of proof is clearly on the processor, on the controller, fiduciary, this point, there is no burden of proof which is clearly outlined, right? So to my mind, if there's a clear good faith belief that this is on a public forum and this public forum requires people to consent to their data being put out publicly, then to my mind, couldn't we just argue that this is caused to be made public? Just putting it out there.
I want to quickly jump in here just to, kind of tie up this conversation and also point out the illustration, because it's super interesting that we've gone from a very high level issue directly into the weeds, which is exactly what I was hoping for from this conversation. But I think what we're referring to, for those of you who are referring to the bill, like good audience members, is Section 3, Subclause C. And it is interesting because my own understanding as well, I should say to Vivek, Arun, and Sriya, was that it is actually an exemption. I mean, it limits the scope of the bill to anything that has been made publicly available or caused to be made. And I like the illustration there. It says X is an individual, while blogging her views, has publicly made available her personal data on social media, in which case the act does not apply. And I think this is interesting just to provide a contrast to the EU position, in that, where people are on social media posting pictures which has other people's personal data, for instance, pictures or video which has other people featured, the individual is then seen as a data controller. So very much it seems that if there is publicly available information, there's still personal data rights that are attached, because the right to privacy there can still be violated. And so it's interesting here. It seems that the choice in India is to say that if you, no win, no fail, if you put your data out there, you no longer have personal data protection rights as an individual. I understand the liability issue, though, that Vivek is raising here, that, potentially if you do use that, could there be some kind of standard around whether that was caused to made publicly available? But I think the fact of the matter from an individual perspective is that you then no longer have any of the rights. We have a short set of rights over here. And what's interesting, just to move the conversation on, and I'm happy to come back to this in the Q&A, because I know we have about 10 to 10 minutes of conversation left between us. So I want to touch on a few other areas. So one of the rights that has been removed, for instance, is the right to data portability. And I think this brings us back to this conversation that we started in, which again has very high level implications around data as an asset and cross-border data flows, but also very specific, provisions in the bill. So the removal of the right to data portability and this idea that data should be made portable only through consent managers, for instance. So we are imagining a world which has a very different, to that opening point of the culture of non-compliance in India. We are, on the one hand, saying in India, we don't really comply, we have very low data protection standards. But the vision in this bill really seems to be that you have consented data flows that are generally, put through these consent managers, and individuals don't have a right to data portability. That's really, the subject of organization to organization, kind of data flows. My question to the panelists here is, how do you see that impacting private data flows? And then to come back, if we have time, to that whole question of the state. So what happens if you have all of this very structured data flows in the private sector? How do you see that affecting, data is just data. It doesn't matter which entity is holding it at the end of the day. So creating a very leaky bucket. But the first question I had is, how do you see the whole consent manager framework and this whole idea of data flows operating without a data portability playing out? I don't know if anybody has views on that. Specifically, I was going to come to Sriya, but Arun or Ameen, if you have them, Vivek.
I'll just kick off. I mean, consent manager is one of the aspects of this bill that concerns me the most. It's great in theory, but to my mind, for it to work, it has to be digital public infrastructure. It has to work off a common platform. It has to speak in clear interoperable terms, and it has to effectively be various people communicating the same language, so to speak. Now, we've all seen with ONDC the issues that, even doing this in a space like commerce has had. With the account aggregator framework, we've seen, for instance, the innovative approaches that various folks take to interpreting some of this, even when the architecture of that consent was very clearly laid down by a very, very demanding and very, very prescriptive regulator. And here you have a situation where you're effectively putting, to some degree, the fox in charge of the hen house. Because some of the largest consent managers, quote unquote, unless of course they prescribe enough stuff to the contrary in the rules, will potentially be entities which have access to large data sets. And effectively, they will be, to some degree, motivated to express and create and signify consent in a manner that is palatable and sustainable for private data flows. And again, because of network effect, the largest consent manager who has the access to the largest number of data sets, assuming that consent manager appointment is an exclusive thing, right? You can't have two consent managers to whom you have given two different kinds of consent on the exact same data set. That would break the system. assuming that you can only either do it with only one or that it's naturally heritable in some form, to my mind, the largest consent manager is effectively going to de facto control the market because they are going to have the largest number of consents to share or modify approach or whatever. And the largest consent manager is going to be the person who can throw the biggest resources at the problem and has access to the most data sets. So I actually worry a lot about this consent manager framework. I'd love to hear from folks on this call if you see it differently.
Yeah, so thanks for that, Arun, for setting the context. I find this consent manager framework to actually be pretty exciting. I mean, perhaps exciting and concerning in equal measure. The first thing I'm extremely happy about is, as somebody who works in the account aggregator space every day, is to finally see the conceptual confusion of a consent manager not being classified as data fiduciary. This was a classification that I thought was blatantly incorrect because a consent manager, especially one like an account aggregator, is completely data blind. It actually cannot even see the data passing through it. It cannot store it. It's entirely encrypted. So it would make sense. It would make no sense for an account aggregator, for example, to be considered a data fiduciary because it has no determination of the purpose or means of processing. On the actual operationalization of the right of data portability, I think that the correct conceptualization of a consent manager, now coupled with the criteria of accessible, transparent, and interoperable platform, even though there is no explicit right to data portability anymore, I'm actually fairly optimistic that the requirement for interoperability could be a way to, on the back end, operationalize the right to data portability. Because by definition, if you have to have interoperable platforms with each other, you would need that data to be portable across each platform. So I think that creating this conceptualization could lead us to see several other sectoral consent managers like account aggregators. I think right now account aggregators are possibly the biggest working example, and the ecosystem is growing every single day with new account aggregators, new new use cases evolving for the ecosystem. And I think we can draw a lot from that ecosystem to the operationalization of other sectoral consent managers. But again, I think going back to a theme that we talked about earlier in the discussion as well, I think this is also going to be a heavily sectorally dependent issue, a heavily sectorally dependent type of implementation. And we would need to see how that plays out. And that is a cause for concern for me. Because, for example, again, taking account aggregators, you see in this bill, there is a vague requirement for consent managers to register with the board and comply with technical organization and so measures that may be prescribed in the future. Now, sectoral consent managers like account aggregators are already extremely heavily regulated to the extent that an account aggregator is, from a regulatory perspective, mandated to only conduct that business and that business only. It cannot even touch any other business. So given that it would have to again now go see whether we have to register with the board, what other technical measures would have to be implemented in addition to what the RBI has already put on the ecosystem. That I think is a cause for concern, and perhaps that will only be clear through subsequent rules. To what extent it will overlap, where already there is already sectoral framework for a certain consent manager.
I have two predictions on this consent manager. Number one, I think this will create sectoral consent managers. We'll have a social media consent manager. We'll have a health consent manager, and I think it'll create probably and that's a good progress of the industry. The second prediction I would make is that there will be a huge fights, challenges, conflicts between consent managers and data fiduciaries. Some data fiduciaries have a sophisticated consent system. Some have a much more bundled blocking consent, take it or leave it kind of a consent. And if those consent systems do not marry well with the consent manager, I see a conflict going there. Consent manager will say, ask the data fiduciary, you modify your consent system to fix it. The data fiduciary is saying, nothing in the law requires me to modify my consent system. I will do what is the least required by law. I think I see those challenges coming in.
Yeah, and that's a very right statement, Vivek, because that challenge is actually currently extremely present in the account aggregator ecosystem with various banks and what we call financial information providers who need to be the sources of that data, and in this situation they would be the data fiduciaries. The integrations between them and the different account aggregators and the consent parameters and systems in place, there is a lot of conflict between these two entities. So I think we're already seeing that in action, and definitely I'm wondering how that's going to play out in different sectors, because of course financial data is very extremely tightly held by whatever institution it belongs to, and I'm wondering if it will be more or less prevalent depending on the sector.
So we have about 3 or 4 minutes left, and I just want to kind of start bringing us to the last bits of this conversation before we go to Q&A, so we can keep talking. Interesting question that I think Arun was also raising is there's two things happening with consent in this previous discussion. On the one hand, we say that from the previous bill, we've gone to a less granular consent, right? Like there were many requirements for consent, and now we just have this clause which says it should have affirmative action. So to my mind, it seems that the granular consent regime doesn't seem to hold anymore, and you have more flexibility. But I'm curious whether you think that that is not the case, whether it is a granular consent regime at all. But the second question that I wanted to wrap up this section with before we go to Q&A is that this kind of focus on consent, what does it say about new intermediaries? So you're putting in place a new class of intermediaries, consent managers, and to the point that Arun was raising originally about the shift in the locus of power, that these powerful new intermediaries will in effect be in a place of controlling data flows. What are the kinds of liability or kind of responsibility regimes that we want to put in place around those intermediaries, presuming that this will actually happen, right? Presuming that there will be a culture of compliance, and presuming that the world will be all consented data flows, which is by no means something that we can take for granted. So I don't know if people had any thoughts on that, and then I'm happy to wrap up. There are a few questions that we wanted to deal with which we're not going to, but hopefully they'll come up in the Q&A. I just want to throw that back to the panelists to close off this section.
Let me take the first one, and Arun can probably, or whoever can take this. On the first one, I think the law requires granular consent. We use 3 words: free, specific, and unconditional. Free and specific are there in the GDPR. Unconditional is an Indian innovation. These words free and specific have been interpreted to mean choice and granularity in consent requests. I think sooner rather than later, that requirement will flow into Indian law. I know there's capability to take other interpretations, but I think I would say, if you ask me to put my bets, I think we are in the world of granular consent requests.
Sorry, if I can just respond to that, right? And they had a very interesting word earlier. And look, the rules may solve all of this, and they may all be sort of put to rest. But they had an interesting word there, which they talked about itemized. Now, to my mind, itemized and the explanation of the word itemized clearly contradicted the earlier part of the sentence, because it basically said a bunch of consents expressed as a list. And to my mind, that basically meant bundling. In our conversations, to some degree, there seems to have been at least a conscious call, or at least an intent to move away from granular consent, at least at the level of the drafter. So, curious in terms of how we see that interpretation of that word itemized from the last round and its removal. Just in terms of while I know it's not really relevant in terms of prosecution history as Topple, at least. In terms of the intent of the drafter here, curious to see what the group thinks on it.
I also just wanted to make a point on the granularity. I think I also agree with Vivek's assessment. I feel that the 5 conditions that are there, that it needs to be free, informed, unconditional, and ambiguous. We are going to see the granularity. If I'm not mistaken, the rules are going to prescribe how the notice needs to be given and how that consent needs to be secured. My guess would be that that is where each of these different criteria will be fleshed out more, and the granularity would probably come in with the government saying that when we say informed consent, you need to get basically these ABCD things in your notice to ensure that it is informed. Unambiguous needs to be there. And secondly, yes, I agree. I also feel that these are the kind of conditions where even in other jurisdictions, I feel the jurisprudence usually evolves the granularity. And I feel here as well, as and when we go into challenges of whether consent was unambiguously afforded or not, the granularity is going to creep in. I don't think that these are terms which just the way they are, like there are connotations attached to it, and that those connotations are the granularity, and I think they will get unpacked in time, both in the rules that bring out the notice templates as well as the jurisprudence that evolves on how consent is to be given in accordance with this provision.
Yeah, I was actually going to
go ahead.
Sorry. If I just perhaps, I know we're running out of time, so maybe a minute or so. I was actually going to make a similar point as Ameen did, which is, I mean, even if you see the approach to that the European Data Protection Board took, right? It has released detailed guidelines over time on what is free, what is informed, what is specific, what is itemized. Like each word has a different European Data Protection Board guideline, and I think that is definitely agree with Ameen on. I think that's what we're going to see. But I also think this is kind of a bill, an act of paradoxes when it comes to consent in a certain way, because we have a new requirement now, which I've been curious, it's been bothering me since the first time I read it, which is now, it's not that, so when I enter a platform, it does not seem like it's going to be enough anymore to just agree to a privacy policy and that's it, you're there on that platform. Now under Section 5, there is a specific requirement that if you have multiple touch points within your platform, your app, your website, where you are specifically collecting data. And I think it gives a very happily fintech specific example with video KYC. You need to give a specific notice at that touch point. So I think it has that level of granularity. And as well, the paradox is the removal of definitions like harm entirely, right? Harm before had a definition that, like, for example, psychological manipulation, which actually, dark patterns which create psychological manipulation count on users in order to create that deception. And actually finishing that consent loop would have involved adequately addressing these manipulative systems which take advantage of your consent. So that's why this is an act of a bit of paradoxes to me. We're going to at once see granularity, but it's not going to solve for those situations which take advantage of your consent.
Thanks, Sriya. And I think that actually this brings us very well into the Q&A session, because one of the questions we've all been saying, we need more regulation, we need more rules and guidelines. But as we know, the DPB doesn't really have rule-making power. So I suppose we'll be looking back to MeitY to create these kinds of regulations. We don't really have an implementation timeline. This law is now an act, but my understanding is we need a notification to bring it into force. So again, we're in this interesting limbo period. I'm going to move into Q&A right now. So we're happy, I think, unless the Law and Tech Society jump in and tell me not to. I see a lot of the participants are actually, great thinkers in the space in their own right. So I would be happy for them to be able to jump in and ask their questions. But to kick off with the first open question that we have, from Paramjeet Singh is, how does this bill impact foreign organizations operating in India remotely? So for instance, embassies who collect personal data for visa processing. Does this bill address it? So again, the cross-border data flow provision obviously gives exemptions, and also the data processor provision says that if you're an Indian entity processing foreign people's data under a foreign contract, you really don't have obligations under the bill. But I think this question is the flip. What happens if you're a foreign entity processing Indian data? Any of the panelists want to jump in and answer this one? And then please keep the questions coming from the audience.
I would consider travel as a service, and it's in connection with the offering of goods and services in India. So to my mind, it would be covered. Now, to my mind, enforcement is going to be tricky. It is consular territory. It is a consular action. So, from a public international law perspective, I doubt if, so let's assume for a minute, hypothetically, that, the US Embassy collects biometric information and processes it in a manner which is not permissible under the Indian constitutional framework. I honestly don't know what the Data Protection Board in India could do, even if they were to pass, for instance, a penalty against it, given that this is a consular action and it is for the obtaining of a benefit in that particular territory. I don't know if you could say this is offering of goods and services in India to that extent. So to my mind, interesting contradiction, and maybe something where the bill technically applies, but remedy may not apply.
It's a clear exemption in international law. I think they'll get greater set of protections because that will be governed by American law, which is probably in some cases more protective than us. I wouldn't think the Indian law would apply at all on that.
Sorry, would you see that as a consular exception, Vivek, or more as a?
No, it's a pure, when a foreign embassy is operating, it's considered as an extension of that country.
Sorry, I'm really sorry to do this. Do you think that would apply to overseas data repositories? Because one of the interesting provisions you might have seen in the budget speech of 2022 is enabling overseas data repositories to be established in India by way of, by way of notification. So basically, say Malaysia comes and opens a data center in India, that is considered sovereign Malaysian territory for the purposes of Indian law, and basically they store their citizens' data there. Do you think that would also be covered under this consular exception?
Yeah, if it's anything which is an extension of that country, if they get the diplomatic immunity, they get immunity from the laws itself.
Okay.
Okay.
Thank you. Super interesting. So basically the territorial application, the scope section under 3 would be vacated because they're an embassy. Very interesting. I think we have a couple more questions, but I'm going to ask the participants, invite them. If they do have a question, you can actually raise a request, which means that you can ask it in your own voice as opposed to be funneled through me. So please feel free to raise a request and then we can get you to jump in and ask the question as well. Very interesting question which has come in, which was on our agenda to talk about. So I'm going to bring it back to everyone here. Views on the composition, strength and independence of the Data Protection Board. Big one. So I'll hand it back. I think the first person I saw smiling, it was a tie between Ameen and Sriya. And then of course, Arun and Vivek, please jump in. So back to the panelists.
Ameen, you want to go ahead?
You can go first.
No, I think it's definitely not a secret what I think by now, because memes are the poetry of my generation. So the first thing I did after reading that bill is put out a meme on LinkedIn, which was the 2 Spider-Man memes, and one was the central government and one was the Data Protection Board, and they were pointing at each other. I think that about sums up what I have to say about the independence of the Data Protection Board. And with that, I will hand it over to Ameen.
I mean, I have, okay, like probably a bit contentious, but I think I'm happy to at least see things like they've put in some basic provisions which are like, okay, we will have a fixed tenure, your remuneration will not be changed or affected by the government. Those are typically elements that we do associate with independence, but I feel at the day's end, it's basically the fact that all these appointments in the DPB are essentially going to be government driven. And the fact that you have taken away rule-making powers in itself from the DPB and reduced it primarily to a judicial or a quasi-judicial adjudicator at this point. And in that, I feel, again, like I was happy that they have added one composition of someone with a legal mind. I am not sure if a legal mind is the same in pure, like given that we've had several Supreme Court judgments on this, I don't think a legal mind, because the way they defined it, could literally be a legal academic who works on data protection law and they add that person to the composition. I think the judiciary's indication on when they talk about having a judicial mind on quasi-judicial bodies is very clear. It needs to be someone who's an equivalent in tenure and in stature and experience to a high court judge or a Supreme Court judge. With that kind of experience, I think that is significantly lacking. That seems to be a trend that has been the case with a lot of these tech regulatory organizations, or they've created, whether it is under the intermediary guidelines or now under this DPDP Act. I think they generally are averse to the idea of having a judicial mind. And we know that the judiciary is very keen on having it. It's a settled position of law at this point. So more than independence, I think that these are going to be points of conflict. I think that they've tried to, like, unlike what the 2022 iteration did, where they just took away the complete powers of the DPB and said that we are going to create it and these are the broad functions that it is going to perform. It has fleshed it out a bit more. They've said that, this is going to be the composition, this is the tenure, these are going to be the remuneration, etc. So in that sense, I think they're trying to mimic how similar quasi-judicial bodies look in other laws, other Indian laws. But at the same time, I feel the composition itself is flawed, particularly on the aspect of judicial mind, which is critical given that this is now basically a quasi-judicial arbiter. So those are my thoughts on it.
Just 10 seconds. I'm worried that there's already a widespread expectation in the community that we will evaluate the effectiveness of the DPB by how much penalties they have levied. Like in the first year, like is there $1 billion penalty, or maybe not $1 billion because that's no longer there, but how much penalties, how much have levied? I think in the developing countries, when we see privacy regulators, I think the ideal case has been that in the first couple of years, we should expect the regulator more to be a privacy advocate rather than the privacy penalizer. I think because there's a huge culture of non-compliance, people are still not sure what the law means. I think that's the aim, at least that's the yardstick in the first 2 or 3 years. And the law sort of empowers them by voluntary commitments. I find a non-compliance, okay, this is what the guidance we are giving. Now you give a commitment that you'll comply with it. That would be an ideal way forward as opposed to starting penalties on day one.
Sorry, can I ask a follow-up question to this? Vivek, what's your, so I'm like happy that you brought up this idea of like the DPB or any such board being like an advocate. So I think that's also part of like somewhat similar to the functions that the CCI performs in the competition space, which is like it's a quasi-regulator, but at the same time, it's also like an advocate for having better practices, etc. The fact that they've now basically rolled back that side of the DPB's functionality and essentially reduced it to an arbiter. Do you think that advocacy element will still go through effectively, like just through like putting guidelines on companies and saying do this? But is that enough advocacy, or should they have some more powers in terms of advocacy or functions in terms of advocacy?
Ideally, they should, at least we suggested advanced ruling so that people can come and say, hey, I have this question, tell us this thing. All of that is not there, but at least one element of where they can still use that is that they can take voluntary commitments. I find a hospital sharing data with pharmaceutical company. I say, hey, this is not, you can't do this going forward. And they give a commitment and they publicize that. So that's the way by which they can build standards.
One question I just had as a follow-up for everybody, more definitely just more of a question than anything. I don't know if it was there in the previous drafts. If it was, please correct me if I'm wrong. But the fact that the Data Protection Board is a body corporate, that is very interesting to me. So I don't think I saw it in any of the previous drafts. I think this is the first time it's a body corporate. So I mean, because the CCI, as you said, is like established under a certain legislation. Similarly, other quasi-judicial bodies are established under certain regulations. Are we looking at the Data Protection Board as some sort of like Section 8 company, like an NPCI sort of regulator? I'm just curious what everybody thinks about its corporate structure.
My understanding is that is fairly common in certain authorities, but I defer to the panelists. My understanding is that body corporate is fairly, and it was certainly in previous versions, in the 2018, 2019 versions of this bill. But Arun, Vivek, I wonder if you had any thoughts on this?
I can safely say it would not make a difference because irrespective, it would be under control of the government. I didn't see body corporate in the previous. It said it shall be an independent body, but I didn't see the language. But I think actually it would not make a difference is what I would think.
I wanted to pick up quickly because it also links to the next question and something that you mentioned, which is this idea of a voluntary undertaking that is there in this bill, that while proceedings are ongoing, you can come in and do a voluntary undertaking to put in place certain data protection measures. Now, this is very interesting because it to me, it seems to map to what the FTC can do, for instance, the privacy enforcer in the US, where you can basically go in and have some kinds of settlements in the middle, also in relation to behavior. What is interesting, though, is that normally these are not often made public. So I'm not sure if they will be made public to create a culture of compliance in India. But also to Ameen's earlier point, in most data protection authorities in the world, they're also advisory within government. So to create privacy kind of culture, and there's no word privacy mentioned in this bill, so maybe it's not a privacy bill. Normally they're at the table when you're creating, say, national security legislation or you're making a decision about the NAT grid. That function, because I was wondering if you had any thoughts about the independence that way, right? Because by cutting them down mainly to be grievance redress, and then maybe this voluntary undertaking is some way they can give some guidance. It really seems like they are not there to set rules or create cultures, at least to the outside observer.
So to my mind, right, this peaceful voluntary undertaking, this peaceful informal alternative dispute resolution, the criteria which are tiered in terms of how they put penalties. This is a theme that is running past even the telecom bill. I think somewhere somebody in that ministry is fond of flexible regulation. It's a theme that's coming across multiple places. I wouldn't be surprised to see it in the Digital India bill when it comes out. I feel that voluntary undertakings, at least as understood, are a situation where someone may go to this regulator and even before any investigation starts, before any breach, before anything else, and say, dear body, I believe I may not be compliant with the law in these ways, or I believe that I'm compliant with the law, but this is my reading of it, right? And for instance, granular consent may actually be a great way for us to stress test this, right? To come back and say, well, yes, it says A, B, C, D, E, but your notice rules don't say it. You used to have the word itemized. I therefore believe that by listing all the purposes, I am adequately getting consent from my users. Please confirm. Now, to my mind, and the second way to do this may be there's a data breach. The black letter of the law says you have to notify every individual data subject. To my mind, you can still go make a voluntary undertaking saying, dear dash, letter of the law says what notify every data subject. To my mind, there is no value to notifying every data subject here because it is name, phone number, and email address. There is no value. There's nothing that can happen, blah, blah, blah. So please dispense or exempt me from this requirement. And I think the third one may be, well, yes, I've been in breach. Going forward, I agree to have ISO 27001 certification for everything. Please don't, slap me so hard. I'm making an undertaking to you. And the third part is actually justified by the new language that's been added, which says, to the extent you've taken some undertaking and you sort of come back from it, you breach that undertaking, the original penalty will apply. So clearly the third use case is clearly justified or put in place by this. To my mind, it's a mechanism to make this person look more approachable and more accessible and sort of open the door for negotiated settlements, which, by the way, Malavika, I also feel is a reason why we don't have a clear implementation timeline on this, right? Because it's a negotiated settlement like everything else that's happening these days. That being said, I just want to wrap this up with one thing. I don't think we should be under any illusions that this is a regulator. I have fundamental concerns with that as a concept. There is a body which sits with MHA when the new national securities law is being drafted. There is a body that sits with, the RBI and advises the RBI when there's a new this thing. That body is MeitY. This is a clear, and you will see this even in the telecom law, where MeitY has, or DOT in that case, has held back significant powers to itself, even as a consequence of trial. Fundamentally, this is the government saying, let us do both the executive and legislative function of governance. You are in the enforcement function, and not even the enforcement function, you are the dispute resolution function. To me, the closest analogy to this is the National Consumer Redressal Forum, not the CCI, not the, and it's not even the National Consumer Redressal Forum, right? Because appeal lies to TDSAT, which is already an existing body, so it's even lower than that. It's State Consumer Redressal.
That's a chirpy note, I think, to start to close these proceedings on. I know we only have 5 minutes left, and I do want to leave some time for wrap up to the Law and Tech Society, but we have 3 open questions that I just want to kind of throw out to the panelists. Feel free to yes or no any of these. I think Sharon has added just one now, but sorry, Sharon, you already had another one answered. But I think the previous ones, they come back to this point of implementation. One of the questions, and I think maybe Arun, your answer started to look at this, is that what should we expect of delegated legislation? When will this delegated legislation come? How should we think about, what are your views? I'm very curious personally how you're seeing this based on your interactions within and outside government too. There's one question around penalties, which I think we touched on a little bit, but is penalty sufficient, deterrence to breach? Great big picture question. And then the last one is the deletion of the right to be forgotten. It's quite an interesting one. What other panelists thought, because I think globally there was a lot of kind of lauding of the fact that we had this in our bill. Obviously that's been removed. So on any of these 3, if all of you want to kind of jump in, I'm going to give you 2 or 3 minutes. Please feel free to jump in. I think Sriya could go first, and then maybe Ameen, whoever else, and then Arun. And then I'll hand back over to the Law and Tech Society, but I'll wait for you all to finish before doing that. Thank you so much. Over to you, Sriya.
I think I'm going to take the question on the right to be forgotten, just because I have written about this in the past. I have kind of yelled to anybody who will listen that I think this had to be in the bill, in the act, God. In the act, and I was one of the terribly disappointed ones. And I said this even on the last session. My understanding is that they're looking to bring it in the Digital India Act. I am not sure what is the timeline for that coming out. But regardless, we are in desperate need of some legislative guidance because of the. I have been closely tracking the number of cases that have come about in various high courts on the right to be forgotten. Each high court taking a different interpretation than the last one. Each high court framing the issue in a different way than the last one. And I think this is a very it's a, I'm struggling for the term. The only thing I can think of is underlooked or underrated, but it's an issue that people aren't paying too much attention to, in my humble opinion, because it is an issue that comes to the absolute heart of the interaction between individual privacy and public interest. And it isn't as simple as, there's no use for this information anymore, so redact it, or there's reputational loss to me, so redacted from the internet. It isn't as simple as that, especially as you start to walk into the line of public figures. What use is that information to the public? What is the different criteria for why that information might be useful in the future, and therefore we make a case for that not to be redacted. It is actually at the very, very heart of public interest and the right to information. And given that, at least having some even broad loose criteria in the legislation would have definitely been an improvement over what it is now, because each high court has a different idea of what the issue is. Even there is no even consensus on what is the right to be forgotten and what is this right. So definitely I strongly advocate for some sort of legislative guidance on this.
Sorry, I had a contrary perspective. I'm really sorry, but there is a right
to 30 seconds, unfortunately. I feel like an anchor on some news channel. But yeah, if you could.
I promise to reflect that. But there is a right to erasure, a very strong, unqualified, untrammeled one. There is a deemed obsolescence clause, right, which basically says we will prescribe statutory periods, and if someone has not contacted you within that statutory period, you will have to mandatorily erase and cause your processor to be erased. Now, the tricky part, of course, is that retention doesn't apply to the government, so that's a whole carve-out. But barring that, to some degree, at least for private individuals, they seem to have enabled it in a backdoor way.
Yeah, absolutely. What I mean is that it's not so much the right being present, because the right is even currently, that is what made people go to court anyway. Even in the SPDI rules, there was some form of right to review, correction, and erasure of your information if you wanted to. But actually creating some criteria for, like the GDPR does in Article 17 or so, if I'm not wrong, and like the UK does under its ICO guidance, creating some sort of criteria for balancing public access to that information and redacting it in the interest of individual privacy. I think that was the issue that I was sort of hoping to see addressed in the act.
Yeah, I'll take 5 seconds because I'm concerned, Malavika. I strongly believe that as pure the constitutional law, right to be forgotten will not fly the test of Article 19. That's why it's not there in the US. It's a purely European innovation and confined to Europe. If you look at the restrictions on right to free speech, public interest is not one of the restrictions. It's there for every other fundamental right. The right to carry on business, you can restrict on the fundamental right. But public interest has been conspicuously been removed as a restriction on free speech. So if I'm a criminal and it's up on the public record, you can't remove it 20 years down the line saying that, hey, it's in public interest. That's not allowed. Europe can get away with it, but I don't think it satisfies the textual criteria. I know Supreme Court judgment and high courts have referred this, but I don't think it has properly fallen for consideration. Sorry, Malavika, I wanted to be within the time.
Yeah, of course. Thank you so much. And actually, this is my opportunity to ask all of the audience and the panelists as well. If your schedules permit, we can just stay for 10 more minutes and go through this, because I certainly am happy to do so. But I know you might have is that fine from the panelist side? If that is, then we can go for 10 more minutes. Great. Yeah, I mean, just to clarify, I mean, on the right to be forgotten, the Google versus Spain case and the other ones as well in Europe, one is a public interest, but I think one of it is also the role of search engines, right? So this is not merely against the data fiduciary. That's where it gets interesting, is that even where the data fiduciary might have a right, like you say, it's a truth is defense to defamation. It's not necessarily defamation. If somebody committed a crime, as a newspaper, you will continue to have it. The question is that if a search engine keeps on putting that on the top of the list, so in that case, in the Google versus Spain's case, it was a question of insolvency, and insolvency records themselves fall away after 7 years because the broader financial sector regulation is that people should be given a second chance. We are having insolvency regulation in India, the idea of a fresh start. But the thing is that with Google search engines and this kind of new datafied space, there is no fresh start. You could have been insolvent once or twice, and now you may have made a fantastic career as a business person or whatever, but that is always following around. So I think that's kind of the one of the issues. But as Sriya says, I think it's very hard to untangle these issues. So is it a defamation issue? Is it a privacy issue? Is it a new datafied issue in that something sticks to you in a way that maybe in our generations, right, the generation that grew up with smartphones, there may be things that they've done which normally is actually fine, but maybe they are unable to escape, kind of cradle to grave scenario. Did anyone have anything on the other two questions that were posed as well, or should we move to, because now we do have another question. I think, Ameen, did you want to come in on one of them? Or
No, mine was also on the right to.
Oh, please go ahead. Yeah,
governance.
since we have a bit more time, please go ahead.
No, but like I think mostly it's been covered, but I will just add like one bit. I think to me at least, the fact that right to be so as Arun pointed out, we have a right to erasure, we have a right to correction, review of data, etc. For me, I think from the privacy standpoint, those are the elements that need to be preserved in a data protection legislation. I think the right to be forgotten, as you rightly figured, is it intersects with more domains, which is why if it comes under a Digital India Act, which is more about the digital users' existence on the internet or within the cyberspace and the rights that they have as a digital user, I legislatively feel that is a better place to integrate this kind of a legislation. And I hope if and when that happens, then as Sriya was pointing out, that it brings out some of those clarities in terms of where does public interest lie, where a right to be forgotten cannot be clearly exercised, or where someone can legitimately claim a right to be forgotten and public interest takes a secondary stage. But very honestly, like I will say, like on a pragmatic scale, I think the way high courts have dealt with it to a certain extent, most recently this Kerala High Court's judgment which came out, I think to me they have in effect given some guidance. Like the Kerala High Court judgment actually does put out certain criteria in terms of like where, given the fact that you are talking about judicial precedents to be raised, it is something that it's not just about public interest, it's also about the fact that these are court records, these are public records, and having the ability to just claim as an individual needs to take a secondary seat. This is not just a privacy issue. So I am a bit like, my personal opinion favors that side, where it is part of having an open courts and transparency in your court proceedings. And I do recognize there are some sensitive provisions, probably like I don't know, like if a full erasure of records is needed, or you can redact the sensitive information, maybe that is like a common ground that you can find between the two elements. But yeah, I hope some of this gets redressed. But legislatively, I don't think this finds place in a privacy, like in a data protection law. I think it needs to be in a more general internet usage or internet existence legislation, which is what I feel the Digital India Act will be. So,
Malavika, just this bill marks the death of, I'm advising some media, marks the death of investigative journalism. If I have to capture somebody, and obviously the person who's being investigated will never give consent. And even if I grab it, he can put in an erasure request on next day and I have to delete it. So that's I don't know how there's some journalistic exception in the Sri Krishna Committee bill, but I think that's gone now.
That's another big oversight,
gone.
I think.
That's
a huge, another one of the big departures, I think. I mean, I just don't understand how, I just presume they can put it under the research exemption, which is incredibly wide if you ask me as a researcher. They collect a lot of personal data, but thankfully I'm currently, covered by the GDPR. I guess that brings us to the last one, which is a great one to close it on, which is this idea of prospects. We're in this limbo. We have an act. We don't have a notification bringing it into force. We're looking forward to delegated legislation. I'd love to do a last round and any closing thoughts from each of you, just on how you see this playing out and things that you will be thinking about in the years ahead. So maybe I can, just looking on my screen, maybe we can begin with Arun, move to Sriya, Ameen, and then Vivek has the last word. If that works, over to you, Arun.
Vivek always has the last word. That being said, sorry, couldn't resist. I see rules coming out in the next 6 months. I made the point on urgency up front. Obviously, it's an interesting time. I wonder what this special session of Parliament is about, and maybe Vivek can tell us. But unless we're going into an accelerated election season, at which point all bets are off. But unless that happens, I think there is significant will to getting this enforced. It's an idea whose time has come. I feel that at one level, there is a significant fear that the next big data breach, the Attorney General or Solicitor General is going to get pulled up and said, and asked why the bill is not yet enforced. And so people are hard at work on the rules. I know that I know that for a fact. So 6 months is what I would say, and then some form of phased implementation. If I were a foreign large foreign significant data fiduciary, I'd be very worried about this because I would think I'd be first in line to have this sort of come down on my head. Although we have been arguing that because the obligations for significant data fiduciaries are so much higher and so much more granular, and because you effectively need a de facto data protection impact assessment across hundreds and thousands of products and services and platforms and repositories and processing actions, they do actually need more time, not less, to comply. But I would think that you'll see a phase-wise compliance, and offshore large entities are going to be first on the at the tip of it, and then some form of negotiated rollout. And I also feel to some extent that in terms of enforcement, somebody said this, I forget who said this on the session, but the validity and the existence of this wonderful new sort of, I won't call it a regulator, I will call it an enforcer. This wonderful new enforcer will be dependent on how relevant they are. And unfortunately, the one way for them to stay relevant, because they can't give guidance, they don't have the ability to do so. They don't have the ability to step in and affect policy. They don't have the way to give any sort of that. The only way they can be relevant to the ecosystem is by handing down penalties. They have to speak through their penalties. So I would actually see them jumping in sooner rather than later.
Yeah, thank you, Arun, for that context. I agree with a lot of what you've said, I think. And I would also hope that there is a sense of urgency in the enactment and, wearing my business and in-house counsel in-house counsel hat, sorry. I definitely want to see the rules because there is a lot of gray area. There is a lot of, in the industry, many people are not sure how exactly to comply, and compliance is cost, of course. So we don't know whether to undertake that cost at this point or wait for the future so as not to, overestimate it at this point. So in terms of consent and different other granular requirements, I'm really hoping that some rules and guidance come out. From the perspective of my sector, definitely the point about significant data fiduciaries is also a concern because there are some sectors like financial services, which by nature are dependent on high volumes of sensitive data. And a big question that has been around in the industry is, does this mean we are all automatically susceptible to becoming significant data fiduciaries? And do we start preparing for that right now? Again, there is no answer. Of course, on my non-business citizen hat, what I would hope to see more conversations on, I'm not sure if we're going to get rules on this, and I'm not honestly optimistic given the trajectory of the bill, but I'm really hoping we're going to start thinking about moving beyond consent and about things like dark patterns and manipulative online experiences, which take advantage of your consent, and that is how they thrive. And to solve for that, we're going to need to move beyond consent. It's great that we're here as a first step, but to move beyond that, start thinking of broader questions, especially in the Indian context where so many, like thousands, millions of people are getting on the internet for the first time. So these are my closing thoughts, and thanks everyone for a great discussion.
I think for me, like the one aspect that I'm curious, not curious, but like I will be hoping for more debate. I'm expecting some form of a constitutional challenge to the sweeping government exemptions. Literally, I don't know, like I don't know if any, like I doubt anyone here is going to raise them, but if like I have a feeling that those provisions are the ones that are likely to get tested very, very quickly, even on a shorter timeline than the rules coming into place. Because very honestly, like we couldn't get to the questions of surveillance, but I think the exemptions that we've had, again, like there is this general argument to be made that whether a data protection bill in itself is the be all end all space for surveillance reform, because again, surveillance intersects with procedure, due process, and things like that. Privacy is one significant aspect that gets affected by it. But the fact that they've given a clean chit, and they've continued to give this clean chit through the different iterations to the government. Seems like, and this is coming in the hindsight of, judgments, like not judgment, but the order in Pegasus, etc., which are very problematic from an enforcement point. But the fact is that the judiciary seems to have also been very clear and critical on this sweeping approach that the executive seems to take when it comes to intelligence gathering or surveillance, etc. You juxtapose it to the fact that in the EU's AI Act now, for the first time, we are actually seeing a very significant limitation on technologies like facial recognition and general biometric identification, especially in public spaces in real time. And even for post real time verification, they have like this whole idea of bringing in judicial warrants or some kind of judicial oversight. We're coming into this kind of an ecosystem with a very different mindset, despite the fact being vocal about we don't want to mimic China in our legislation. Our legislation seems to be much more in alignment with what the Chinese are doing, or what more authoritarian regimes are doing in surveillance than not. And I think this is an aspect which is again problematic, not just from a privacy lens, but also from a constitutional, from a due process lens, from a fundamental rights perspective. I am curious to see how this unpacks. My bet would be that this is going to get assailed sooner than later. But yeah, I'm curious to see how it unpacks. And thanks again for having me and for excellent moderation, Malavika. Thank you.
Yeah, finally, just to summarize the collective intelligence which I'm getting, these rules will come in place before the elections. The government wants a lot of action on the digital side. They want citizens to get a bunch of notices to showcase that the fact that the act has come. So you will find a lot of digital notices coming through before the elections. So, and two, enforcement will happen probably, as they're saying, in their third term in 2024. And three, I see a lot of constitutional challenges, but I work closely on surveillance under Section 69. Those challenges have been pending for a year. This is surveillance reform of data processing. The underlying surveillance itself, the court has not got to that Section 69, where without any judicial safeguards. So if this envelops into that one, I think I don't see that guidance coming at least till the mid of next year. Thanks again. Thanks for this. Is very insightful.
Yeah. And thank you, everyone. I'm just going to hand back to Law and Tech Society. Again, just before I do, a great thanks to the panelists. I didn't expect to cover as much as we did, honestly, and I've learned a lot. So thank you so much. I do want to say, I do feel especially bad that we didn't get deeper conversation on surveillance and on this point, because I do think, for those of you who will be following this for the rest of your law school, where we started was this idea that we don't have a culture of privacy, right? I just hope we don't have to have some kind of digital holocaust in order to start caring about our facial recognition, our biometric systems, because we have come up with some pretty potent systems. We've kind of just, been sold these systems for various reasons, including, big kind of large commercial reasons. I don't quite know whether even our political leaders understand. They may understand certain use cases. I don't know whether they understand how much power even legislative or democratic system gives up to these systems. So with that, back to Shikhar and Sridhar. Thank you so much for all your help in getting us together. We really appreciated the conversation. Thank you.
Thank you, Malavika, for an excellent moderation. I think you were in the proverbial immoderate moderator, as you mentioned in your mail. Quite the contrast. And this vote of thanks is on behalf of Sridhar. He can't access his Zoom because of some technical reasons. So as is the procedure, the joint convener delivers the vote. But starting off, I'll just pick on something else that Malavika posted on her socials last night. She credited the Law and Technology Society to always have high content and low BS discussions. And I don't know, I certainly feel that this discussion over the past 1.5 for 1 hour 45 minutes was certainly one such high quality discussion. I personally learned a lot. We covered topics ranging from general data protection, AI implications, right to erasure versus right to be forgotten. And now Malavika just ended on a very interesting point on surveillance. On a personal note, I'm grateful to all of you because this is the last event that I'm doing as the convener. My term has technically already ended. We got a special exemption for this because so many of you were interested in having us organize this event. And Well, thank you all. We hope that the committee, if not me, it continues to engage with all of you in the future. Have a good day.
Thank you. Thank you so much.
Thank you.
Thank you.
Thank you. Bye-bye. Thank you.
Bye.
Thanks again, Malavika.
Thank you. Bye.